It's 9:30. Madam Clerk, roll call, please.
Each member is acknowledging that they are attending the meeting via Zoom, that they are located in Wayne County, Michigan, unless otherwise stated when I call your name. Commissioner Killeen. Commissioner Dobb.
Here, I'm in South Haven, Michigan.
Thank you. Commissioner Clark Coleman.
What did you say? Who did you say?
Clark Coleman.
Oh, here.
Commissioner Kniezek. Chair Basham.
Here.
You have a quorum present.
Next item, Madam Clerk.
Chair's remarks.
None for the meeting. Next item.
C, approval of the July 28, 2021 meeting minutes.
Can I get a motion?
Move approval.
Support.
Support. Okay, it's moved and supported. All those in favor?
Aye.
Aye.
Aye. All those opposed? The ayes have it. Next item.
D, unfinished business. There is none listed.
Okay. Next item.
Item 1, under new business, communication from Marcella Cora, Wayne County Legislative Auditor General, forwarding the copy of the Office of Legislative Auditor General's Performance Audit Report on the Wayne County Treasurer's Office forfeiture, foreclosure, and auction process.
Well, I'd like to welcome our Auditor General, Ms. Cora, her staff, and also her guests. So, Ms. Cora, please proceed.
Marcy Cora, Auditor General, and if staff could introduce themselves, and John has a PowerPoint presentation. So staff, if you could introduce yourself.
Will Hamner, Audit Manager.
Welcome.
John Kellett, Supervisory Auditor.
Welcome.
Tequila Allen, Principal Senior Auditor.
Welcome.
Erica Jones, Senior Auditor.
Welcome.
And we also have representatives from the Treasurer's Office, if they could introduce themselves.
Good morning, Javier Adams, Chief Deputy Treasurer.
Good morning, James Berry, Deputy Treasurer, Forfeiture and Foreclosure.
Good morning, Tony Cavalli, Assistant Deputy Treasurer, Forfeiture and Foreclosure.
Okay, please proceed.
Okay, what you have before you today, this is a performance audit of the Treasurer's forfeiture, foreclosure, and auction process. This engagement originated when a complaint was filed with the Ethics Board that was ultimately dismissed by the board, but our office was requested by the Commission to perform an audit of the forfeiture, foreclosure, and auction process to ensure that policies and procedures in place would reduce the risks, to ensure that the process, was fair, consistent, equitable to all homeowners. Any recommendations in this engagement from the audit perspective was trying to help ensure that all homeowners have the same opportunity to redeem their homes. Under no circumstances do we want to see a homeowner lose their homes. We think the Treasurer is doing a great job keeping homeowners in their homes, and we commend him for that. We merely want to ensure that the process is fair and equitable to everybody, and there is sunshine on the process. This engagement took a considerable amount of time. We strive in our office to complete engagements as quickly as possible. However, many factors go into the length of the time an engagement may take. The forfeiture, foreclosure, and auctions process is a very complex process. And our office, like many throughout the county, are short-staffed, and the pandemic impacted this engagement as our staff had to acclimate to working remotely. We believe this engagement is very detailed, and it does provide an independent assessment with some recommendations that we hope could improve policies and procedures to help ensure that everybody is getting the same, not only getting the same fair and equitable treatment, but there is also the appearance that everybody's getting that treatment. So I just wanted to make that statement, and I will turn it over to Will Hamner, and they will go through the presentation.
Yes, as Marcy indicated, we conducted a performance audit of the Treasurer's Office as it relates to the forfeiture, foreclosure, and auction processes. We had two primary objectives for this audit. The first was to assess compliance with rules, regulations, laws, county ordinances. And then the second was to assess the controls, effectiveness of the controls over the processes within the forfeiture, foreclosure, and auction areas. The scope of the engagement primarily encompassed the period of October 1, 2016 through January 31, 2019. And again, to address the objectives, we met with management officials. We did analytical reviews, procedures, performed observations, examined a significant amount of detail during the fieldwork procedures. Some background information. The Wayne County Treasurer administers the collection of delinquent taxes, forfeiture, and foreclosure processes under the Delinquent Property Tax Foreclosure Public Act 123 of 1999. PA 123 amended the General Property Tax Act to subject delinquent property to forfeiture, foreclosure, and sale over a 3-year period. I believe prior to that time, it was a 5-year period. According to PA 123, property owners with taxes that are 3-year delinquent will be foreclosed, and ultimately their property will be sold at public auction. One thing I would like to bring out is that over the past several years, the Wayne County Treasurer's Office has implemented several measures that allow taxpayers to pay their delinquent taxes in order to avoid this foreclosure of their homes. Those examples of those measures include the establishment of the what they call TAPs, or taxpayer assistance programs, locating kiosk machines throughout the county that afford taxpayers the convenience of paying their taxes locally. In addition, we've noted the Treasurer has performed numerous community outreach efforts by communicating these established programs to assist the taxpayers. For the performance engagement, we identified 10 issues which contain 30 recommendations in an effort to strengthen the Treasurer's Office's internal control environment over the forfeiture, foreclosure, and auction process. From the 10 issues, 2 of the issues are considered significant deficiencies that are classified as medium risk and may require immediate corrective action by management. And then 8 of the issues are control deficiencies are considered or classified as low risk. We discussed the issues, the report, and the recommendations with representatives from the Treasurer's Office. Management agreed with 2 of the issues, partially agreed with 1, and disagreed with 7.
Will you say that again? They disagree with 7 of the issues?
Yes, they disagree with 7 of the issues. Mm-hmm.
And then let me just say this, you go by national auditing standards, correct?
Yes, all our audits are conducted under national standards, yes.
Okay, then please proceed.
Okay. Okay, for the engagement results, I'll turn it over to John Kellett, Tequila Allen, and Erica Jones.
Tequila Allen, Principal Senior Auditor. Under our first objective, which was to assess the compliance with the rules, regulations, and state laws, we have adherence to the foreclosure timeline established by PA 123, which is on pages 6 through 8 of the report. We assessed the WCTO's adherence to the 3-year tax foreclosure timeline established by PA 123. For our analysis, we identified properties listed on the foreclosure listing for 2 consecutive years, 2017 and 2018. From the sample of 50 selected, we noted the following exceptions. 6 partials had property taxes that were partially paid or paid in full after the foreclosure date. 4 taxpayers entered payment agreements after the foreclosure date. 1 parcel was foreclosed to a municipality 20 months after the foreclosure date, and 1 residential property was incorrectly coded by the WCTO as industrial and never entered the foreclosure process. We determined the assessor's office had recorded the property as residential. Failure to adhere to the foreclosure deadline established in PA 123 without documenting reasons for exceptions could be perceived as unfair and not equitable if some taxpayers are allowed to retain their properties after the foreclosure deadline. This could result in potential litigation to the county. Our first recommendation is a significant deficiency. In order to establish fair and equitable treatment for all taxpayers, we recommend that the Treasurer's Office ensure eligible taxpayers are placed into WCTO tax assistance programs prior to the foreclosure deadline date and document those taxpayer exceptions whose homes were not foreclosed on at the foreclosure deadline date in accordance with Public Act 123 of 1999. Management agreed with the recommendation.
If I could just state here, with this recommendation, we are not saying that all homeowners that are delinquent on their taxes as of March 31st need to have their homes foreclosed on. What we're saying, if there are exceptions as to why homeowners are given extensions or additional time, just document it in the file. So if there's any questions down the road, at least everybody knows what the reasons were. We're just trying to make sure there's sunshine on the process and everybody's treated fair and equitable. But no way are we advocating that all homeowners should be foreclosed on March 31st if they're delinquent on their taxes. So I just wanted to make that statement.
Okay, and does the Treasurer's Office agree with you on that?
There's representatives on the Treasurer's Office.
Mr. Chair?
Yes.
We agreed with the findings. We did have a response prepared for that. And I also have a statement that the Treasurer asked me to read this morning when it's appropriate with respect to our response. But we did agree with the finding. We take some exceptions with the recommendation. So I don't know if you want me to go into that now or if you want me to read the statement.
If you take exception to recommendation, I think we should go into it. But now, when we started a meeting, I asked which I already know the answer to, the question to the auditors. You know, they go by national auditing standards. They don't do their own thing. So when the auditors come up with recommendations, we try to do the Rodney King thing and all row together. And so I'm very interested in hearing your response. Thank you.
And I'd like to respond to that as well. The standards that they used were never presented to us. And I don't believe that there are national standards for their findings. They don't point those out throughout their report. They don't set them forward, what the standards are. We frequently heard that this is best practice, but we never got the best practice in writing or the derivation of the best practice throughout the audit.
And so we can clear this up. Can I have somebody, Ms. Cora, respond to that?
Well, do you want to respond to that?
Sure. Within the report on page 4, I'll just read this right under the scope section. It indicates we conducted this performance audit in accordance with generally accepted governmental auditing standards issued by the Comptroller General of the United States. These standards require that we plan and perform the audit to obtain sufficient appropriate evidence to provide a reasonable basis for our findings and conclusions based on our audit objectives. We believe the evidence obtained provides a reasonable basis for our conclusions based on our audit objectives. And that's in the report. And we always, every audit performance audit we conduct will be under these standards, and we will identify them in the report itself.
Just to clear it up, is the Treasurer's Office okay with that response?
No, we are not. I mean, it's one thing to say that there are general standards set forth, but there's another thing to point to the specific violation of a particular standard. And we have not seen any particular standard set forth throughout the investigation.
So, Ms. Cora, how do we get
if I can add, the standards are as how we conduct our audits. There would not be standards as far as what the recommendations and findings are. The standards relate to our processes in place that we have as we perform these engagements. So you would not find a standard related to this recommendation. It's just how our processes is. And we're peer reviewed for these processes.
Yes.
So there is not going to be a standard related to this recommendation. The standards are our processes.
And again, it's my job to chair the meeting, which I've been doing for a number of years, and the Auditor General staff have been doing this per auditing standards, and then auditors from other states come in and do a peer review of our auditors. Plus, there is checks and balances here. So I want you to understand the treasurer's office, it's not like we're picking on the treasurer's office. We have a responsibility to audit different departments regularly. We intend on doing that. And sometimes there's pushback and sometimes there's not. But at the end of the day, this won't go away until we all get on the same page and row in the same direction. So that's just my 2 cents worth.
If I could
Sure.
make a statement too, when we develop our recommendations, these are recommendations that we believe based on independent assessment, they could help the treasurer's office. If the treasurer's office decides not to implement our recommendation, then they're accepting the risk of not implementing the recommendations. We would never want that to happen. We would rather work with the treasurer's office so we can develop recommendations that are going to make the processes, fair and equitable to all homeowners, and try and enhance the processes for somebody from the outside looking in.
And I absolutely agree with that. So,
and I'm sorry.
That's all right.
We agree with that also, but there are some exceptions that we took note of, and I think that's why it's important to note our responses to the findings.
Well, and again, I know some departments start off with those positions like you just stated, but at the end of the day, the issues, the recommendations, actually this is to help the treasurer, not to hamper or hurt the treasurer, but also the treasurer is part of Wayne County, which I'm part of. And so we have an obligation to try to sort out our differences so we can understand where each other is coming from. And so I would hope that the treasurer's office would understand where the auditor general and her staff are coming from and where I'm coming from as chair of audit.
We absolutely do.
Okay, thank you. Oh, please proceed.
Mr. Chair.
Yes.
Could I ask a question?
Absolutely.
Thank you. Did I hear correctly that the Wayne County Treasurer's Office is not aware of the generally accepted governmental accounting procedures?
No, that is not what we said.
Okay. I just wanted to clear that up.
And these were not accounting procedures used in this audit.
Okay.
For clarification.
Okay. So the auditing, I'm sorry, go ahead, Marcy.
No, I was just saying they're the generally accepted auditing procedures.
So the auditing procedures they weren't aware of?
No, we were aware of them. What we asked for were specific standards that we violated. And Ms. Cora clarified that these were performance standards and they did not set forth a standard for each of the findings.
Right. The auditing procedures would not do that.
Okay, thank you. Thank you, Mr. Chair.
Okay, moving right along. Thank you.
Mr. Chair?
Sure. Commissioner Kleen.
Yeah. Good morning, Mr. Chair.
Morning.
I think we're talking past each other right now.
Right.
So I want to go back to the first recommendation here that management agrees with. And I think, that discussion might come up in later recommendations, but is what the Wayne County Treasurer's Office saying is that they can place eligible taxpayers within assistance programs before the foreclosure deadline. Is that what the Treasurer's Office is saying, is they're going to do that or can do that, or what?
We agree that we violated the statute to the letter of the law. We also note that we do have the ability to place taxpayers in tax payment plans, as well as the treasurer has a broad discretion in withholding properties from the tax foreclosure auction.
And I think the issue here is that we want to document that we're not picking and choose who we determined to be on this side or the other side, that we're treating all these foreclosed properties the same, that there's no reason to try to get people foreclosed on if they're like $1,500 is all they owe on their property. So why would we do something like that? So that's my thing. So anyway, we'll move right along.
Mr.
Yes.
Chair, Mr. Chair, Do I still have the floor?
You do if you want. Yes.
Yeah, thank you. I want to specifically go back to the treasurer's office because the recommendation says ensure eligible taxpayers are placed within a tax assistance program. Is that what the county treasurer's office is committing to today, that they will ensure that taxpayers are placed within a tax assistance program prior to the foreclosure deadline? Or are there exceptions there? If there's exceptions, I'm listening.
There are exceptions.
Okay, I'm willing to listen.
Okay, so we have worked extensively with the courts, and I'd like to read our response, if I may.
Sure.
As I think it's important that that be part of the record as well.
Absolutely.
Okay. The Wayne County Treasurer's Office notes generally that fair and equitable treatment of all taxpayers has been established and that taxpayers of all classes are allowed the opportunity to enter payment plans and redeem parcels prior to the entry of the final judgment or foreclosure. And I would note that frequently the final judgment or foreclosure has been after March 31st. We have worked with the courts on that. No class of taxpayers has been excluded by the Wayne County Treasurer's Office or by the Circuit Court in extending the period of redemption for foreclosed properties. While we agree with the findings on this issue, we believe it important that the history of this practice provide context for our response. The longstanding practice of the Wayne County Treasurer's Office and the Circuit Court has been to allow for a modification of the petition for foreclosure before the final judgment of foreclosure is entered, particularly for taxpayers claiming lack of notice or inadequate notice, or those suffering extreme hardship. The Circuit Court retains discretion to modify its order upon a request by the Wayne County Treasurer's Office for properties paying off delinquent taxes. And we note Section 78H2 of the General Property Tax Act, which provides in pertinent part, if the property is redeemed after a petition of foreclosure is filed under this action, the foreclosing government unit shall request that the Circuit Court remove that property from the petition of foreclosure before entry of the final judgment foreclosing the property. The Circuit Court has historically exercised discretion in extending the time for the issuance of the final judgment of foreclosure because of the unique situation of Wayne County in addressing objections and providing the required hearings for tens of thousands of properties with delinquent taxes each year. In almost every instance noticed by the OAG as a failure to comply with the foreclosure timeline, the actions allowed for removal from the petition of foreclose was done prior to the entry of a final judgment foreclosing the property in accordance with 21178H and with the consent of the court. This process has been used successfully and with the cooperation of the courts to mitigate the risk of potential litigation noted by the OAG and subsequent financial liability to the county, as well as to alleviate the pressure on the Circuit Court docket to complete thousands of foreclosure objections hearings prior to mid-March each year. This is also the case for properties whose owners have entered into a stipulated payment agreement as allowed by the Circuit Court. Any changes to the schedule without the extension of the redemption period will be submitted to the Circuit Court for concurrence. Additionally, the Wayne County Treasurer's Office notes Section 78H3 of the General Property Tax Act allows for removal of properties for reasons specified therein. The Wayne County Treasurer's Office notes that the OAG has added the word only to the statutory language that provides the reasons that the foreclosing government unit may remove properties. However, there is no such exclusive language contained within the General Property Tax Act. Moreover, the OAG focuses on only a limited number of reasons allowed for the removal of properties. There are more, including persons without means of support or persons unable to manage their affairs due to age or infirmity until a guardian is appointed to protect the person's rights and interests.
Okay.
Given the history, can I
go
finish?
ahead? Yes, go
Given
ahead.
the history and the extreme number of foreclosures in Wayne County prior to 2015, resulting in a loss of revenues for the county, and we attached, we included an attachment for illustration. It is almost inconceivable that the OAG would recommend that this longstanding practice, with the consent of the courts, be discontinued at this time, especially given that it is open to all taxpayers and not a specific class. The Wayne County Treasurer's Office will continue to allow for the removal of such properties in all instances allowed under state law.
I think, let me jump in for a second. I think, you know, it's not about picking and choose. It's like sunshine on the processes where, and you made reference to the risk of the OAG. So the OAG is recommending that we treat everybody the same, not that we pick and choose who we help or hurt. You know, to drill down on this thing, to follow the recommendations of the OAG, which is often referred to in your statement, I think is a positive thing, because the OAG wants to help the treasurer, wants to stop lawsuits, wants to help people that can't afford to pay their taxes that could set them on a payment plan. I don't think the OAG is trying to do any of that stuff to hurt people that want to stay in their homes. So if I'm wrong, I would hope that the OAG would set me straight on this.
No, you are correct. And as I stated in my opening statement, we commend the Treasurer's Office for everything that they're doing to keep homeowners in their homes. All that we're looking for is just to make sure there's documentation, so that if there's any exception why a home was not foreclosed, at least it's documented in the files so that everybody is aware. No way do we want homeowners to be thrown out of their homes and not being able to redeem them. You know, anything the Treasurer's Office can do to keep homeowners in their homes, that's great. We're all for that.
So having said that, can they're talking about documentation, can't the Treasurer's Office give us that consistent documentation in a central location?
Yes, we can. And I'd like to place this in context, our response. Sure. Because while the OAG is saying that they're doing this to help the treasurer and that they want to keep taxpayers in their homes, initially the recommendation was that we foreclose immediately and increase the revenues for the county. So that stance has changed tremendously from the initial recommendations presented to our office. And if I may, I would say that that provides the context for many of our responses to the original recommendations made by the OAG's office. So we are glad that they came around to this position, but in the beginning, we had recommendations that were primarily to increase the number of foreclosures and drive revenue to the county.
Okay, and if I can get the OAG's office to respond to that comment.
Can you respond to that, please?
Sure. Unfortunately, I would have to disagree with you, John Vier. At no point in time during this audit did we ever look at you foreclosing on homeowners' properties or increasing revenues. That wasn't our objectives. Our objectives primarily were to look at your operations and see if we could enhance your control environment. Our audit procedures are driven by risks. What are the most risky areas that would lead to exposure or, put the treasurer in a bad predicament? So these particular recommendations that we have in front of us, by saying document those exceptions, we're saying, okay, let's bring some transparency to the decision-making process that's being conducted over at the Treasurer's Office for third-party review. As it relates, that was B. As it relates to A, all we're saying is those taxpayers that are eligible, we can assist them by placing them in the TAP programs prior to the foreclosure date. That was pretty much the long and short of it. No way would we ever want you to foreclose on anyone's homes, because that could be of a family member or etc. That never was our objective. So I believe we worked through this process, and I think we've got you to agree to these recommendations. So I think from here we can move forward, I hope.
So is this a Rodney King moment? We can all get along? Okay. Okay, moving forward. Please proceed.
Mr. Chair?
Yes, Commissioner Lane.
Yeah, I'm going with the hands up thing, trying to anyway. Okay. And, these are very sensitive issues for homeowners that I think everybody agrees on. So I just want some real clarity here. I listened to Ms. Adams' answer, read it in the report. It's a very tersely written kind of a legal document. It's hard to parse everything out in their answer, but I want to go back to the recommendation. The key word in A apparently is eligible taxpayers. So I want to know two things from the treasurer's office. Are you going to be able to ensure that eligible taxpayers are put in plans before the foreclosure deadline? And then those that, and you cited a lot of this in the law, but there are going to be exceptions to this. And the second recommendation is when there are exceptions, if I have this right, Madam Auditor General, that those exceptions are recorded on a separate list and explained why they are exceptions. So those are the two things in this recommendation. First, is the Treasurer's Office going to ensure that all eligible taxpayers go into a payment plan or foreclosure? And then secondly, where there are recommendations under the law, are those going to be recorded and be a public document so everyone can see why?
Ms. Corr, could you respond to Commissioner Kling?
That's what our recommendation is. And as far as a public document, that's something that somebody maybe in legal can, but what we're looking for is just something in documentation that files within the treasurer's office for a reason why a home maybe was not foreclosed on.
Okay, before I hear from the treasurer's office, then I'll retract the public document part of my comment.
We weren't looking for that.
But just that there's a list somewhere of people that were not eligible and how they're being handled, or why they're not eligible and how they're being handled. So is that it, Ms. Adams from the treasurer's office? Everybody goes on a payment plan if they're eligible before the foreclosure, and those that are not eligible are recorded separately and the reason why they are not eligible.
So to be frank, we have extended the deadline for entry into payment plans each year with the consent and cooperation of the court. And as far as us ensuring that they are placed within the programs prior to the foreclosure deadline, we are going to make every effort. We are going to consult with the court to make sure that there is not a huge negative impact on the schedule of the judicial foreclosure hearings as we compact that time and reduce the number of days that taxpayers may be able to enter into payment plans. So we will make every effort, but I will say that in the past, it has been extended with the cooperation of the court system.
And if you could correct me if I'm wrong, if the court's extending the foreclosure deadline, allowing additional time for the payment plans, and that the adherence to the foreclosure timeline, that is extended by the court, so that would be allowable.
Correct.
Correct?
Yep.
And on B, I would further add that we do make an effort to document the exceptions within our property tax administration system. We include comments on the parcels that are withheld from foreclosure after the final judicial foreclosure hearing.
So we're going to get back on track here. Will, you want to proceed?
Yes. Next slide. John, I think that's you.
Yep, I'm going to take this one. This was our second area of concern, and this one dealt with developing a process in order to validate mailing notifications to the taxpayers. And this can be found starting on page 8 of the report. Here, we assessed compliance with the sending of notification letters out to the property owners. We randomly selected a sample of 52 parcels from the 2018 foreclosure population to assess. We ended up reviewing 2 of the 3 mailings to determine if the notifications were remitted to the taxpayers in accordance with PA 123. Here we have, starting with the delinquency notification in year 1, and then also in year 1, the forfeiture notification. The third one, which is in year 2, is the show cause hearing notification. And we didn't focus any of our attention to that because that's sent out by certified mail and it's guaranteed. So based on this, we determined that the Treasurer's Office sends a database of taxpayers' property addresses to the contracted mailers. And the county contracts with 2 different vendors on this. We were unable to verify if the taxpayers' notifications were actually mailed by the dates mandated by the Act. According to management, the contractors send an email back to the treasurer's office acknowledging the mailing had been sent. However, when we requested to review copies of these, management stated that the contractors' emails could not be readily retrieved. At the time we did our walkthrough, I think it was indicated to us that there were several individuals within the office that could have received the emails, and it would have taken them some time to locate those. Management did state, though, that the contracted mailers are required to meet the terms of the contract. And then also during one of our walkthroughs with one of the vendors, we became aware that that one vendor did not maintain a log of the returned mail-in tax payments upon receipt. What we were told is on occasion for each of these mailings, they may get a few return letters back where the taxpayer will use the return address of the vendor and send their tax payment to them instead of using the treasurer's office address. So a couple consequences here with that. Not having a process to adequately monitor compliance of notification mailings based on the mailing contract or agreements could lead to property owners not receiving adequate notification of delinquent property taxes. And then also payments returned to a mailing contractor without adequate tracking and accountability provides a risk that these payments may be lost or stolen and could possibly lead to a forfeiture or foreclosure of the taxpayer's home. And this leads us to our second recommendation, which we identified as a control deficiency. In order to mitigate the risks related to past due tax notifications, we recommend management within the treasurer's office develop a formal process to ensure that all notifications sent from mailing contractors regarding the dates that the notifications are mailed to the property tax owners are compiled and retained for subsequent verification, and require the mailing contractors to log any tax payments that are returned to them and forward the payments and the log to the treasurer's office for review and processing. And management disagreed with this.
Yeah.
Please proceed.
Okay, at this time, I'll turn it over to Erica Jones, who's going to take the next issue.
Yes, as part of...
Before starting, Mr. Chair, did you want a response from the treasurer?
If you'd like to respond, sure, absolutely.
Okay, thank you. Good morning, everyone. My name is Jim Berry. I'm the Deputy Treasurer of Forfeiture and Foreclosure. Just started in the position, but for 13 years, I was the attorney representing the treasurer in the foreclosure process. And I just want to add to the written comments that are contained in Appendix A. I don't want to restate those, but I just want to point out something, that the particular delinquency notices that Mr. Kellett is referring to, these are not required notices for purposes of establishing due process either under the statute or the Constitution. And that's very important to note, because when we send certified mail notice, that is subject to minimum due process, that is subject to constitutional due process, and we validate the sending of the certified mail notices. With respect to these delinquency notices, I note that Mr. Kellett indicated that there's no verification that the notices were received. That's a very important point to make, is that the law does not require receipt of the notices. We don't have to show receipt. We only have to show that the notice was in fact sent. And that's true with the certified mailing notices, which are really the relevant notices for the foreclosure forfeiture process for purposes of whether or not it's a valid foreclosure. The delinquency notices, if we set up a system where we're verifying the receipt of those notices, that's going to provide a basis for taxpayers to now contest our provision of that notice. We don't want to go there. That would be a huge mistake as a matter of legal practice. We need to maintain the current practice of validating the certified mail notices. With respect to what the vendors do, I don't take exception to Mr. Kellett's recommendation there. You know, they should be able to provide us a list of who they mail to, because they've gotten that list of who's delinquent on their taxes. But that's never posed a problem ever in any legal challenge in court. Those notices have never, let me repeat, have never posed a challenge in court because they are not required. So I just wanted the commission to understand that there are reasons for not implementing procedures that would require verification of receipt.
And I appreciate that, but there's always two sides, and I want certainly the auditors to understand the Treasurer's Department, but I certainly want the Treasurer's Department to also understand that the auditing department is not an adversary of the Treasurer's Department. The auditing department is actually, it actually enhances the Treasurer's Department if they're, agree to what the recommendations are from the auditors. So could you respond to that, Marcy?
Yeah,
Well,
I do have a response to this.
Yeah,
This recommendation is merely, it's not requesting that the homeowners confirm receipt of receiving the notification. All we're asking that is when they receive the email back from the mailing contractor that they sent the notifications out, that they retain that email from the contractor that acknowledges, yes, all these mailings were sent out. Nothing regarding the receipt by the homeowners, just that the contractor did indeed mail the mailings out. That's all we're asking, to be retained, that email.
and that don't sound unreasonable. Do you agree with that, James?
Yeah, if I may, Ray, that is not unreasonable. I just note that on page 8 of the report, they say that they were unable to verify if taxpayers actually received the delinquent notification by the dates mandated in the act. And I just wanted to point out that that is not actually an obligation that we have, nor should it be an obligation that we have. But the recommendation, I think, is a valid recommendation, and certainly one that we can implement, and I think that's one we will implement. So I think we're all on the same page there. The thing I just wanted to bring out, Ray, if I could, is perhaps maybe the disconnect on the auditing standards and our response is that the treasurer, as the foreclosing governmental unit, is a creature of statute. Everything we do is pursuant to the General Property Tax Act. And so that's the standard that we look to in determining the policies that we implement. And I can tell you that from the day I started as the attorney back in 2007 here, when the storm really hit and foreclosures went through the roof, I mean, our approach was always to do everything we can to try to keep people in their homes while maintaining the integrity of the Tax Act. And I think we've done a pretty good job through the years of doing that. And it's always been a work in progress with these payment programs and always trying to establish them within the confines of the law. Many payment agreements that were entered into after the judgment of foreclosure, for instance, were done because the taxpayer had filed a written objection to the hearing, and then were given extended court dates beyond the March 31st date, which allowed them still to get into a payment agreement. So we understand the law. We try to work as best we can within the law, but also trying to understand that people are facing a lot of pain. And we want to do everything we can to push the limits of the law to give them the opportunity to stay in their home. And that's, I think, what we do, and we do pretty well.
I think we all agree with that, Commissioner Kleen.
Thank you, Mr. Chair. What percentage of of homes that actually go to the auction, wind up in the auction, are homes that were not, the foreclosure was not challenged by the homeowner. What percent of our cases just go to auction, they're not challenged at all, they don't wind up in circuit court?
I'm not sure that we can provide that that number,
but
right off the top of our heads.
I can say that handling the litigation for the treasurer for 13 years, the amount of litigation has steadily dropped, number one, because the area of law has been well developed and taxpayers understand what they can and cannot do. Number two, it's never been a high percentage. The vast majority, I would bet over 90% of the properties that go to auction are never challenged in court.
Well, I'm just going to observe here. A lot of folks that are in danger of foreclosure have a lot of issues going on in their life, like poverty, like moving frequently, like a lot of things. And the fact, when I look at that and trying to keep people in their home, I understand what you're saying, Mr. Berry, in terms of the compliance with the state statute, but I will observe the treasurers around the state have done some things that you indicate push the limits of the law, and that maybe some of these payment plans may even exceed the limits of the law, right? And then that takes everybody going to court to figure that out. But I think for citizens, well, I could be wrong, Mr. Berry, but it seems to me that outside of the law, that if we make every effort with our contractors to make sure we have put a letter into people's hands that actually own the building, you know, a mailing that doesn't necessarily do it at all. I deal with mailing lists. I know what shows up and what doesn't at people's homes. So I think that the recommendation from the auditor that we, the law notwithstanding, that even outside of the law, that we make every effort to make sure that all of these folks in danger of losing their homes, not that it's checked off on a list somewhere that we send them a letter, because a lot of those letters don't get to the right person. And maybe we should be doing something with our contractors out there, that it takes a knock at the door and a verification that a homeowner was actually talked to that's in danger here. I don't think that would be illegal to do, but it certainly is not something that is mandated by the law. But I don't think that stops us from making every effort to do that. Thank you.
Thank you. Okay, moving right along.
Yes.
Will?
Yes. As part of our second objective to assess the effectiveness of controls over the treasurer's forfeiture, foreclosure, and auction process, we noted an issue regarding the monitoring of taxpayer compliance to IRSPA agreements. This begins on page 10 of the audit report. We performed a limited review of the interest rate reduction plan agreement to determine if taxpayers met program qualifications and remained compliant to the terms of the agreement. Over our audit scoping period, we noted that there were over 5,000 IRSPA applications processed. We tested a sample of 83 agreements and determined non-compliance to the terms of the agreement in the following areas. For most of the sample, we were unable to determine if the taxpayer provided evidence of their principal residence exemption status, which is a requirement to be enrolled in the program at the time of the IRSPA application. We also could not verify that the cashiering cashiers validated the PRE exemption status in the PTA system at the time of enrollment. We also determined that there was inconsistency in how the 10% down payment requirement was being applied for taxpayers enrolling into the program. This is also a requirement of enrollment into the agreement. Management stated that the 10% down payment criteria has not been formalized into policy.
And I guess to that point, somebody from Treasury's Department, have you established a policy for receiving the 10% down payment to enter the program?
Yes, we have. And so we disagreed with this finding because there is a criteria for the 10% down payment program. And I think it's important that we explain our system for the IRSPA agreements because we've had multiple conversations with the OAG on this, and we're still talking past each other on this issue.
Let's talk to each other then. The thing of it is, if you're saying that you're doing the policy for 10% down payment, how can we be talking past each other?
What the OAG focused on was whether the taxpayer made a 10% down payment at the time they entered an agreement. In our office, if a taxpayer has made 10% of more of the delinquent tax payments prior to entering into an agreement, we include that amount in the 10% requirement. So if a taxpayer has made 10% or more, then there is no additional payment required at the time they enter into the IRSPA agreement. If they've made 5%, we require an additional 5% to meet the 10% standard. What we also determined from this is that some taxpayers, even if they're told that they've met the requirement, they want to make an additional payment. We don't prevent them from doing that. So if a taxpayer has met the 10% and they want to make an additional payment, they're allowed to do that towards their payment plan. We don't stick in with just, you have to pay the 10%. We're not going to accept your money, or we're not going to count any payments that you've made toward the 10%.
Okay, so, and to that point, let me stop you at that point. To that point, are you saying from the auditor's department or somebody from the auditor that they can't make more than the 10%?
Well, can you respond to that?
Yeah, no. So just as some background. So when we looked at this area, the application, the enrollment application basically indicates the applicant is to make a 10% down payment. So we took that as the criteria initially. And then we found exceptions, and we discussed this with management. And then we were told, okay, no, the 10% payments made within the same year of the applicant's application can be accepted as part of the 10% down payment. So we looked at that, and we still had some minor exceptions. So we went back and we spoke with management again. Then we were told, no, the 10% down payment can be met with payments over the prior 12 months. So we looked at that. And so that was our final look. And we still had some, I mean, again, that reduced the exception rate. And really all we're saying here pretty much in our recommendations is we never got a policy, a formalized policy as it relates to how the 10% will be. While we were told that's the practice, we never got a policy that stated that. So all we're saying in item number B here is that just formalize the practice for applying the down payments to meet the requirement, to ensure the process is fair and consistent. Because again, what our overall objective is to ensure everyone is treated fairly and consistently. And by doing the formalization of the policy, then it's transparent to everyone.
Okay, and let me stop you there. So I wouldn't think that the Treasurer's Department would have a problem with developing a policy that basically says in writing what they are doing. Is the Treasurer's Department okay with that?
Well, we don't have an issue with establishing the policy. We had an issue with the findings.
Well, I think we're all getting closer to saying the same thing, but if a written policy would probably because some people might say, well, you got to have 10% down payment to get involved in or to get in this program, where others are saying that as long as you within a year contribute at least 10%, can't we clean that up and put it in writing? And then that way we move on and we row together again?
Sure, we can include it in the payment plan.
That's a good thing.
I'd also like to note on the finding for the PRE affidavit, which is included in our answer, and I don't, like Jim said, don't want to read that entire answer, but I think it's important to note that our system was developed in response and in recognition of the process that starts with the local governments and includes the Michigan Tax Tribunal. And so are not necessarily validating a PRE affidavit form. We receive copies of those when our system has not received information from the locals that a PRE is on file with them. And so the recommendation that we ensure the review and validation of the form and the state approval is, how can I say this? It's just wrong because we can't do it. It's something that cannot be done by our office because we don't have the ability to review the state approval.
Well, I think there's common ground there somewhere. If we get the Auditor General and her staff to sit down with the legal folks from the Treasurer's Office and get us there, because this is it's a continuing process. It's don't mean any one person or one agency is wrong. It's just you're seeing things one way, and the auditors per auditing standards are seeing them slightly different. But they're going through this process, even with COVID. It takes so long, but they're going through this process to actually enhance the Treasurer's Office, not to hurt the Treasurer's Office, and also to enhance or help the people that are actually needing help. So to make it consistent, put sunshine on it, stop lawsuits and so on and so forth. I think we all want the same thing. It's just, I think we're looking at it from, a different set of eyes. But I heard you say that you will develop a policy that establishes basically what the OAG has suggested, correct?
I think we have the requirement in the payment agreement, and we will clarify that the 10% can be met with prior payments.
Thank you very much. I appreciate it. And moving right along.
Okay. I also like to add in regards to the condition statement. We also know that taxpayers do not always stay current on the payment of non-delinquent taxes while enrolled into the ERSPA payment program. This was a stipulation within the actual application form that each taxpayer needed to remain current on their non-delinquent taxes and in order to stay current in their program. We believe that by not ensuring all required ERSPA agreement terms and conditions are adhered to could result in the acceptance of ineligible taxpayers. In addition, the agreements could have been deemed no longer effective, resulting in interest being retroactively applied. In addition, without documented evidence of the PRE document and other documents used to evaluate qualifications within the PTA system, we believe in addition, without documented evidence within the PTA system that all program qualifications are met, a third-party reviewer could question the approval of the ERSPA application. And then in regards to the recommendation, I know we've already touched on policy and procedures, but we believe that we recommend for the Wayne County Management to revise and establish policy and procedures to ensure that the PTA system retains the cashier's review and validation of the PRE affidavit form and state approval for subsequent verification by third parties. We also recommend for Wayne County Management to formalize the current business practice for applying down payments to meet ERSPA program requirements to ensure that the process is fair and consistent. We also recommend that the Wayne County Treasurer's Office ensures that adequate monitoring is performed during the year to identify taxpayers who are non-compliant to IRSWA payment agreements, and that non-compliance taxpayers are immediately notified of their potential forfeiture or foreclosure status. And lastly, we believe that the Wayne County Treasurer's Office should monitor the status of IRSWA applications that have been approved to ensure that they are uploaded timely into the PTA system and that all support is attached. And as we noted in the report, management disagreed with this recommendation. And also under the objective of monitoring the controls within the processes, we noted another issue.
Ray, you're on mute.
Thank you. Let me stop you right there. We all want the same thing, but why would management disagree with that? Can somebody from the Treasurer's Department respond to that one?
Yes. Can we go back to the recommendations?
Yes.
And I started discussing A. So, and it's not that we're disagreeing with the goal, but we think that they really, as much as we've talked to them, don't understand the process. So with respect to A, where they ask that we ensure that the PTA system retains the cashier's review and validation of the PRE affidavit form. When a PRE affidavit form is submitted to us, it is just an application that has been submitted to the locals. It does not indicate approval by the local or state approval. So the cashier cannot validate state approval.
Okay.
For most, may I finish please? For most taxpayers who apply for an IRSPA or which the principal residency affidavit exemption is required, it is already uploaded into our system by the local treasurers when they submit their delinquent tax rolls. It is only those taxpayers who do not have that on file that are required to present to us their application, not a form that we can verify for state approval. So that's where we disagree. We can't do that. And within our...
But let me stop you for a second.
Okay.
So Will, can you respond to that one specific thing?
Yeah, sure. So for the this particular area, what we saw, because the enrollment criteria is that you have to, present the PRE form. Within the PTA system, as the applicant is applying, there's a box within the PTA system that the cashier would check saying pre-form, reviewed or assessed or it came in, however, but there's a box in the PTA system that should be checked. When we looked at our sample population and we went to that screen within the PTA system, not the actual form, it's just the screen that says that the cashier is supposed to check. The check was not there. So we're saying, okay, so how, if the check isn't there in the PTA system, which indicates the cashier acknowledged that this pre-form is, in existence, then how do we know it was in existence without the box being checked? And then we were told by the IT director that the check box doesn't always stay in the system after it's checked, or it was something like that. So basically we said, okay.
Can I respond? This is Ramesh.
Can somebody silence their phone?
So, I'm sorry, Mr. Chair. Our information management executive director would like to respond.
Okay.
His name is Ramesh Renati.
Okay. Will, are you done?
Yes. Ramesh, yes, please.
Okay. Then can you respond now? He can respond now. Information.
Thank you. Good morning. Yeah. So the system, as Will said, if somebody has not already entered into a payment plan, that box will show up. But once somebody, the cashier has already verified the information and checked the box, the information is stored in the database in codified form, and we felt that it is not relevant for it once somebody is in a payment plan we thought it is not relevant for it to be shown again and again on the screen because we already have a lot of information on the screen about once somebody is in a payment plan, we show all the schedule and other details. We didn't want to clutter the screen anymore, but the information is stored in the database in a codified form. As a matter of fact, I just wanted to also mention that the cashier doesn't have any leeway on deciding how much is needed for a 10% down payment. The program calculates it, so there is no discretion on the cashier. If somebody has to pay $100 to meet the 10% threshold and they pay only $90, the program doesn't even allow them to enter into a payment plan. So there is a checking done in the property tax administration system. So I think it is a misunderstanding from the auditors that the information was not there. The fact that it is not shown on the screen doesn't mean that the information was not captured. It is captured in the codified form. As a matter of fact, reached out to them saying that to provide us the list of properties which they are reviewing so that we will be able to provide the information back to them. And they were not willing to share they said that is confidential. They can't share which group of parcels they are specifically reviewing.
Okay, I hear what you're saying, but here's where I guess I'm coming from. Every department in the county, you make sense on what you're doing, but a third party should be able to come in and either we have a reason to have, for example, that sampling, that box checked or not checked, that needs to be cleared up so that we're all, again, looking to accomplish the same thing, but the Auditor General is saying one thing because the boxes that they actually looked at weren't checked, and you're saying something else that we don't have to check them, then we should be able to work together and clear that up.
Might I clarify, Mr. Chair? Ramesh, can you let me speak? I'd like to clarify, Mr. Chair.
Yes.
Okay, Ramesh is the master of our property tax administration system, and it's a very robust and efficient system. The system captures when the cashier reviews and validates that an application has been presented. That is required when a taxpayer comes in and they have never been in an IRSPA before, or if it's not coded as having a PRE. So they can't even move forward without checking the box, is what he was saying. They must check the box to move forward. Once they check the box, we capture that. It doesn't say XYZ cashier check the box. It says a PRE is now on file for that property. And so it is retained within the system that there has been a PRE either presented or on file or was formally presented. It's all in our system. We do not have a box that says cashier number 13, check the box on Mr. Basham's PRE for his IRSPA. But it is retained in our system. And so when they say that we should ensure that it retains it, it retains the fact that the PRE has either been presented or is on file, and the cashier's review is required to even move forward with processing the agreement. So we think that what they're asking is beyond what's required. I don't think we need to have cashier number 13 check the box on August 11th at 10:39 a.m.
Okay, first of all, I'm not Mr. Basham, I'm Basham, like don't hit him, Basham.
I'm sorry.
Okay, that's number one. And it's an English name, number two. Second of all, Will, does the Auditor General understand where the treasurer is coming from, and is there a way of finding common ground there?
I'm sure there is, Chair. Again, our recommendation is that when we look at the operations, right, we're looking to see, is things evident that a third party would be able to come in and say yes. Now, if we look at something and we don't see evidence, but however, a particular item, because what I'm hearing the treasurer say, and I totally agree with the process, but if an item is in another file, then how would a third party know that? I mean,
and that's a legitimate question. So, yep, you can, but that's a legitimate question. So we're going to get the response from the Treasurer's Department.
Yeah, I'm going to respond to that. The screen is not meant for the third party who will come once in a while to check. The screen is there for our cashiers to take the payments and to do the payment plans.
Well, so but let me stop you. Let me stop you. There needs to be a screen there for a third party to come in and make sure that they're doing things correctly per auditing standards. So if it's not, you need to fix it.
Yeah, we said we will provide the information if they give us the list of the parcels, but they were not willing to give us the parcels. So if they were to provide the parcels, we would have provided the information that is already there in the database.
Can the Auditor General staff provide the process for them to do that?
Sure.
Okay,
exactly.
That's a yes answer. So, okay, moving right along.
Yes.
Yes, we also evaluated the distressed owner occupant extension program. We performed a limited review of that process in order to determine if taxpayers were compliant to the agreement. We identified a total of 1,400 applications from our audit scoping period and randomly selected a sample of 30 applications to test. Based on our assessment, we know the areas of non-compliance that include but are not limited to the following. 10 of the samples did not have an application form retained or uploaded into the PTA system. For 20 of the samples, the approved applicant either exceeded the household income standards or did not provide the annual income amount on the sworn statement of income. And both of those requirements were stated on the application form as a requirement for enrollment. While we noted 13 of the approved applicants did not pay the delinquent taxes outstanding by the requested deadline as stipulated on the enrollment application. Management indicated that taxpayers are given an extension by law. Management also indicated that the application will be revised to require payment of all delinquent taxes by the statutory deadline. By not consistently obtaining all required program documentation to qualify a participant could result in the acceptance of ineligible taxpayers. In addition, the extended redemption period given to taxpayers is not transparent for third-party verification or review. As part of our recommendation, we believe that this issue was a control deficiency, and we recommend for management within the Wayne County Treasurer's Office to implement policies and procedures to include the following. Ensure cashiers obtain all required documentation from applicants to properly verify eligibility for the program. Ensure cashiers upload the application form and supporting documentation into the PTA system on a timely basis for third-party review and transparency. And also ensure the extended time afforded taxpayers to pay off their delinquent taxes is documented and uploaded into the PTA system. As stated in the audit report, the Wayne County Treasurer's Office agreed to part of our recommendation and disagreed with the other remainder portion.
And what did they disagree with specifically? Well, you want to get on that one?
Not readily.
Okay.
Jean-Pierre, do you want to identify that area that you disagreed with?
That the treasurer disagreed with, not her.
Yes, yes. That's correct.
Thank you.
I'm sorry.
Okay. We agreed that the applications and supporting documents should be uploaded in the PTA system on a timely basis. What we identified was that during periods of high taxpayer volume and staffing, at times there were exceptions being made to the timeliness. We also noted that at that time, the cashiers were new to the process and they did not have individual scanners for each cashier. We have since rectified that by acquiring additional scanners, and the cashiering unit is required to upload all payment plans immediately upon execution of the agreement. So we agreed with that. We were unable to respond to Part B because we did not have additional information, but we noted as a general rule that they must obtain the required documents to support a DUI application. And we noted also that in some instances where an application for a new plan is submitted for a subsequent year and the taxpayer has already been in a DUI, that we are not requiring documents, but we could not verify that without the additional information we requested from the OAG. Then on Part C, we disagreed with that because by statute, the DUI, the distressed owner occupancy extension, is not per se a payment plan. It is an extension of the redemption period. So if, for example, a taxpayer would have been required to redeem by March 31st of this year, and they qualified for the extension, their redemption period is extended until March of the next year. So although, and I don't know, I think this was developed years ago, there was a note in there that the DUI was required to be paid off by December 31st. And I think that's because the payments were calculated to be in 10 monthly payments. But even if it's not paid off by December 31st, we're required to extend that redemption period until March 31st. So it's not that we're affording them additional time and that we should document that, it's afforded by law. So the extension is by law. It just goes until the end of the next redemption period. So I don't know what we would upload and document on that. So that's why we disagreed. We do monitor whether the taxes are paid in full at the end of the extended redemption period. And if they're not paid off, then the parcels are subject to foreclosure. We don't want to be punitive with taxpayers who have not made their payment by December 31st, when in fact the law allows them to March 31st.
But why do some taxpayers who exceed the household income threshold be allowed to participate in the DOOE agreements?
So, and a distressed homeowner can qualify for a number of reasons beyond the statutory federal income poverty guidelines. And I believe those are stated, if not in the agreement itself, on the affidavit and attestation that the taxpayers are required to present. So for instance, if you are a senior and you are unable to handle your affairs, you're allowed to have an extension. And this is within the broad discretion that's granted to the treasurer. So we don't want to limit it to just the income. There are other hardships that distress taxpayers for which we want to allow them to have an extension.
Mm-hmm. Okay, I appreciate that. And on a different note, because there's other meetings coming up, I don't want to rush through this. This is quite extensive. I know it took a couple of years to do, thanks to the pandemic and everything else. And anyway, I appreciate the participation from the Treasurer's Office and the Treasurer himself, also the Auditor General and her staff. So what I'm going to do at this time is try to wrap our meeting up. And could I get a motion to pass for the day?
I will move to pass for the day.
Can I get a second?
I'll support that, Mr. Chair, but I do have a quick question.
Okay. Can we vote on that first? Or
sure.
Okay. All those in favor?
Aye.
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 All those opposed? Aye. Okay. Commissioner Killeen.
Yeah, just for context for today and our future discussion.
Sure.
About how many homes are going into the auction this year? Just so we have an idea of numbers and how many people are involved in this process.
Anybody?
2,800. 2,800. Those are including the vacant lots.
Okay, so that's okay. And then how many people on payment plans?
This year we are foreclosing only unoccupied structures and vacant lots. So only 25 of the foreclosed properties were in payment plan and defaulted.
Okay. So we're dealing with a universe of about 5,000 people.
Okay.
Okay, just for context. Thank you for allowing that, Mr. Chair.
Okay, anything further from commissioners? Okay, well, I appreciate it. Next item, Madam Clerk.
If such other matters as may be properly submitted before the committee.
There are none.
Public comments.
Is there anybody from the public who'd like to comment? Can we unmute the phones? If anybody from the public would like to comment for a second time.
We did receive an email comment.
Okay, could you read it, please?
Yes, this is from Celeste Mintak. She didn't specify which committee it was going to, but she did send it a while ago, so I'll just read it here.
Okay.
It says, good morning, committee members. I'm emailing my comment to present a recommendation to you because I am concerned about the medical discrimination being implemented with vaccine passports that will have a negative impact for the residents of Wayne County.